G'day everybody and welcome to topic 11 for Laws 12063 Advanced Statutory Interpretation and Drafting. I'm Anthony Marinac. This is the first of 2 weeks to round out the Advanced Statutory Interpretation and Drafting course, in which we're going to move away from statute. And over these last 2 weeks we're going to have a look at 4 other types of drafting which are commonly engaged in by lawyers in practice. The reason for this is to show that the drafting skills that we've been practicing through this semester are not simply applicable to statutory drafting. They in fact provide you with the base of skills that you're going to need for drafting all sorts of things in legal practice. So this week we're going to have a look at drafting correspondence and affidavits, and next week we're going to have a look at drafting wills and contracts. So the objectives for this week's lecture: first, we'll look at identifying the purpose of a piece of legal correspondence based on your instructions, and then writing a legally sound piece of correspondence which is appropriately calculated to what your client is trying to accomplish. And second, we'll look at the process of assisting a client to prepare an affidavit to give evidence in typically a lower court civil matter, and how you can do that without compromising your own ethical responsibilities towards the client and the court. So let's start by having a look at legal correspondence. Now, I realise that some of you are looking at this topic and saying, come on, I'm in the final year of my law degree, I don't need somebody to be teaching me how to write a letter. Fair enough call too. However, legal correspondence is one of those interesting things that you find within practice that nobody really takes seriously. And yet the truth is that as a lawyer in practice, you will probably spend more time drafting correspondence than you do drafting any other type of legal documentation. And nowadays, so much of legal disputes are resolved outside the courtroom that it's actually the case that more of your legal work is going to be done through legal correspondence than through any other sort of legal document, unless you're in a specialist field like, say, conveyancing. Because most people don't really regard legal correspondence as real drafting, a lot of lawyers write absolutely terrible legal correspondence. They've never stopped to take it seriously, and so they do it very poorly. You, of course, have the option. You can take it not very seriously as well, and also draft poor legal correspondence. Or you can realise, as we're going to in today's lecture, that legal correspondence actually is fair income drafting, and that the better the skills that we can deploy in the drafting of legal correspondence, the better we're going to do by our client. So let's get underway. The first thing we need to think about when we're drafting legal correspondence is who the recipient is going to be. Typically, you're going to be writing to one of 3 types of people. You may be writing to another lawyer, you may be writing to a professional in a field other than law, or you may be writing to a lay person. Consideration of who you're going to be writing to will let you think very carefully about what tone and level you're going to apply in your writing. If you're writing to another lawyer, then there'll be no problem with using jargon, and there'll be no problem with reference to statute and cases. Any other lawyer who's competent is going to be able to see those things and understand them and use them. As I've said in previous weeks, I would probably still step away from overusing legal Latin and law French, but other than that, you can use as much jargon as you need to get your point across. If you're writing to another professional, say an accountant or a doctor, then you're going to be able to use complex language, and you're going to be able to write a relatively complex piece of correspondence. However, they're not going to necessarily be across legal jargon, so you're going to have to drop the level down just a little bit. If you're writing to a lay person, I recommend dropping the level of your writing down quite considerably. Obviously, many lay people are still going to have exceptionally good skills of literacy and ability to understand correspondence, but unless you actually know the person, you can't be sure whether they're going to understand what you're writing to them. Resist the temptation to write in too complex a manner to try to give over the impression that I'm a lawyer and you're not, and therefore you'd best do as I suggest. Effective communication requires that the other party is going to be able to understand what you're saying. Certainly write in a professional manner and adopt a professional tone, but there's no need to use an over high level, particularly when you're not sure about the literacy level of the person that you're writing to. Before we move on from this topic though, I want to spend a few moments talking about unrepresented litigants. An unrepresented litigant is a person who comes before the court without legal representation. So in this case, you may be representing a client in a dispute against another person, and that person may not have legal representation, so you're going to be dealing directly with them. Unrepresented litigants are now becoming more and more common, particularly in minor commercial disputes, and perhaps most of all in family law disputes. As a legal practitioner, you have a special duty in relation to unrepresented litigants. Simply put, you are not allowed to use your legal training to overwhelm an unrepresented litigant. Where you can, and where you are not acting in a manner that's contrary to the interests of your own client, you should correspond with an unrepresented litigant in a way that enables them to put their case. Now, this doesn't mean you have to give them free kicks. It doesn't mean that you have to give them a hand up. And it doesn't mean that you have to give them advantages that will enable them to argue successfully against your client. What it does mean, however, is that you can't take unfair advantage of the fact that the other person is an unrepresented litigant. We know that they're not going to have the same level of understanding of the law that you do. We know that they're not going to have the same understanding of process that you do. If it seems like you're getting ahead simply because of that lack of understanding, it may be appropriate for you to explain things to an unrepresented litigant in a way that you would never have to if you were writing to another lawyer. So having thought about who the recipient is, we've got a sense of what sort of tone and level we should be adopting for our correspondence. Next thing we need to be thinking about is what are our objectives. And there are two ways to think about our objectives for a piece of correspondence. The first is we want to think about what the overall objective is going to be. At the end of the day, when this legal dispute is fully and completely resolved, where does our client want things to be? How do they want the world to look after this legal dispute is concluded? And once we've got that in mind, how do we expect that this particular piece of correspondence is going to bring that closer? So, what is the task that this correspondence is going to undertake as part of the process of eventually moving towards the outcome that our client seeks? The second question to think about in terms of objectives is, what do we want the other side to do immediately? We might want them to immediately withdraw their application and file a notice of discontinuance. We might want them to immediately respond by indicating whether they'd be prepared to undertake mediation. We might want them to immediately apologise. We might want them to immediately clarify something that they've said in previous correspondence. So you can see, in terms of thinking about the objectives of our correspondence, we need to be taking both a short-term and a long-term view. Overall, what is the destination that we're trying to move this legal dispute towards? And more immediately, what do we want the other side to be doing in response to this correspondence? What is the target? Having thought about that, the next thing you should be thinking about is what we don't want to say. As I've indicated on the slide there, sometimes discretion is the better part of valour. There's two usual reasons why we might want to hold back on something that we might well say in correspondence. First is that obviously sometimes there are facts or legal principles which work against us, which weaken our position or the position of our client. Now obviously we can't lie about those. We can't assert the facts to be assert certain facts that we know are straight out untrue. However, there's no need to serve up to the other side all of the facts which are going to assist them to make their argument. It may be appropriate, particularly early on in a legal dispute, to keep our cards close to our chest and not disclose facts and law which are going to be of too much assistance to the other team. The second way in which discretion is the better part of valour is that you don't want to telegraph your punches. There's no point, for instance, in completely rehearsing the arguments that you might end up using in front of the court in earlier correspondence with the other side. All that does is identifies for them your full argument and your full tactics, which enables them to take time to prepare rebuttals. So think very carefully about whether or not the correspondence might potentially include things that you don't actually want to say. And once you've thought about those, decide which of those things you want to concede or which you want to say now, and which of those you wish to hold back. The final thing to think about, or the final major thing to think about, is what's known as negotiation privilege. And quite often you'll see legal correspondence, and in the header or the footer of the correspondence, the lawyer has written the words "without prejudice." The rule, as most of you will know from having done your professional conduct, the way the rule works is that any correspondence which is part of a bona fide attempt to reach a negotiated settlement is regarded as privileged. It's protected by what's called the negotiation privilege. Now, when someone puts the words "without prejudice" in the header or the footer of correspondence, what they're basically doing is raising a flag and saying, as far as we're concerned, we believe that this correspondence is privileged. The truth is that there's no magic in those words. Correspondence doesn't become privileged simply because somebody puts the words "without prejudice" in the top and bottom of the letter. The only question is whether or not the correspondence is part of a bona fide attempt to reach a negotiated settlement. If it is, then it's privileged, regardless of whether the words are there or not. If it's not, then it's not privileged, even if the words "without prejudice" are written at the top and bottom. So think very carefully about whether or not the correspondence that you're writing is privileged under the negotiation privilege, or whether it is not. And if it is not, be aware that the things that you write can be attached to subsequent affidavits and brought up in court. A couple of last little considerations about legal correspondence. The first one is tone. It's important to adopt a tone which is strong, but which still remains courteous, particularly when you're talking or when you're writing to other lawyers. There are lawyers out there who, when they engage in battle, they go terribly hard. And if you're dealing with them in correspondence, they will attack you in no uncertain terms. Problem is, of course, that later on they're going to come back to you on behalf of another client in another situation. And what are you going to think of them at that point? You see, if you become known as one of those lawyers who's just constantly carping and attacking, someone who brings unnecessary antagonism to a dispute, then you're going to find that your professional reputation gets affected. It is possible and meritorious to represent your client as hard as you possibly can, but you can do so without crossing the line into discourtesy. Professional courtesy is supposed to be one of those things which characterises the practice of law. Unfortunately, these days it's a rule more often observed in the breach, or more often honoured in the breach rather than the observance. Don't be one of those lawyers. Second thing to think about is whether or not your correspondence should be email or snail mail. These days, of course, email is starting to carry the bulk of our written correspondence, and it's very normal for parties in disputes to be passing emails backwards and forwards. The advantage of email, of course, is the fact that it is completely instantaneous, and so you might be able to pass 6 or 7 or more iterations of correspondence with the other side in the same time that you might be able to send one letter through the post. Having said that, letters in the post still have a certain cachet about them, still have a certain sense of importance. Letters in the post also enable you to present them effectively. Letterhead, a signature in ink. There is still value in this form of correspondence, particularly for the most important aspects of your correspondence. It may be best to stick with the old traditional snail mail rather than sending email. My suggestion would be that if you're not sure which is most appropriate, go for snail mail. But if time is of the essence, there's nothing wrong with preparing the snail mail, scanning it, emailing the scan to the other side, and then sending the original through in its own time. Don't get into the habit of just using email as your default. Think carefully about which form of communication is going to best represent whatever your client is trying to achieve from this correspondence. So they're all the things to think about. In terms of drafting legal correspondence, what ought a piece of correspondence to contain? Now, of course, legal correspondence, as opposed to any other form of legal drafting, such as a statute or a will or a contract, legal correspondence is really quite formless in the sense that different letters may require completely different structures and frameworks. However, on the slide and in the notes, I've indicated a basic starting point which I think is going to help for most correspondence. We start with a salutation. A lot of people don't think about the salutation. I think that's a mistake. I think that the choice of a salutation that you make is going to set up the tone for the rest of the letter. In the first paragraph, set the scene. So if this is the first correspondence on a legal dispute, you might indicate that you have been engaged by a certain person, and you might give a very brief outline of the nature of the dispute. When you're setting the scene, you're not actually making any arguments. You're not trying to win any points. You're just orienting the recipient of your correspondence so that they've got some idea what you're on about. Then we would set out our version of the facts. So whatever facts we're relying upon in the argument that we're making in the correspondence should be set out fairly early. After that, we might make our claim or counterclaim. So this is what we say is the legal result of the facts that we've just set out. The claim or counterclaim tends to take a longer perspective, and so that's followed with a much shorter perspective in which we make a demand to say this is what we expect the other side to do. Generally speaking, those demands fit into one of 4 categories. We might be inquiring, in which case we expect an answer. We might be requesting, in which case we expect them to do something. We might be demanding, in which case we really don't see that they have a choice but to do what we're saying. Or we might be asking that they desist, that they stop doing something that they're already doing. Make this claim very clearly towards the end of your correspondence so that there's no doubt about what you're hoping to immediately accomplish through the letter. And then finally, it's important to make a strong finish. Remember that the tone of the letter is going to be markedly characterized by the way that it finishes, because that's going to be the last thing that the person on the other end reads before they put the letter down. Now, in the notes you'll see that I've set an example or an exercise for you to undertake where there's a letter from a company called Mix Import Rares demanding or in relation to a dispute over the supply of some rare car parts to somebody who's come and seen you. The demand has been made for money and your client wants you to write a response. what I'd like you to do is structure your response in terms of the structure that I've indicated. Have a go, and then either place your attempt on the Moodle site or email it through to me so that I can give you some feedback. I want to turn now to the second half of today's topic, which is all about drafting affidavits. What is an affidavit anyway? Well, an affidavit is a statement where a witness is providing facts for the court under oath. It has essentially the same status as testimony which is provided before a court, and it's more or less taken the place in quite a number of different proceedings of evidence in chief. So to give an example, in family law these days it's very unusual for a witness to be able to give evidence in chief before the court. They're much more likely to be expected to provide an affidavit, and then if necessary cross-examination or re-examination may proceed orally. As a result, in an increasing number of types of legal proceeding, your ability to assist clients and clients' witnesses to prepare an effective affidavit will have a very great bearing on the outcome of the trial. Let's have a look at how we can do it effectively. The first question we need to be thinking about is, what is the relevant law and what argument do we intend to make? You see, if we were going to be examining this witness in the courtroom while they were giving their evidence in chief, one of the things that we would be thinking about before we went in there is exactly what argument we were planning to run overall and what the relevant legal basis would be for that argument. You need to have that firmly in mind as you assist the witness to make their affidavit, because that's going to be helpful in terms of guiding them as to what things we want them to talk about and what things are not going to be relevant to this particular case. In terms of that argument you're trying to make, the usual way to do that will be that you understand the legal principles and you understand the legal elements of the argument that you're trying to make. And then in order to make that argument, you're going to be attaching facts to those legal principles. Now, of course, facts don't prove themselves. The only way that we can bring a fact before a court is by having it authenticated by evidence. And that's really the purpose of our affidavit. So the question we're asking ourselves is, what facts that are relevant to the argument we want to run can be authenticated by this particular witness? What can they tell the court about that will make it more likely that the court will believe the version of the facts that we're trying to put? The second thing we might be thinking about is, what documentary evidence that we want to put before the court can be authenticated by this witness? So for instance, if we want to put an email in front of the court and this witness was either the sender or the recipient of that email, the witness is obviously in a position to authenticate that email. And so we might say in the affidavit, I received an email on the 29th of June at 9:37 a.m. and the email contained the following words. So we're thinking about those two things for each witness, for each affidavit. What facts can they authenticate? What documents can they authenticate? Next thing we need to think about is, I need you to dredge up some of the stuff that you would have learned in evidence law. In evidence law, there are 4 questions that we continually ask about each piece of evidence. The first, is the witness's evidence relevant? Second, is the witness's evidence admissible? Third, is the witness's evidence reliable? And fourth, does the witness's evidence have strong probative value? Now, these 4 questions are also important in relation to the content of an affidavit. If a witness's affidavit contains material that is not relevant, then it's pointless, and in fact it may end up being struck out. If the witness's affidavit contains evidence that is inadmissible, so for instance, if it contains lay opinion, or if it contains inadmissible hearsay, or if it contains information which for any other reason compromises the admissibility rules of evidence, then that information is not likely to carry any weight in the affidavit and may well be struck out. So there's no point including it. Third thing we should be thinking about is whether the witness's evidence is reliable. On what basis do we think that they're telling the truth, and on what basis do we think that the observations that they made were adequately supported? Finally, does the evidence have strong probative value? Does it actually help us to make the case that we're trying to make? If it doesn't, then of course there's not really any point that evidence being before the court. The final thing we need to think about before we start writing an affidavit is the deponent or witness. If you're sitting down to assist somebody to make an affidavit, the first thing you must do is assure yourself that that deponent understands what an affidavit is and understands what penalties may apply if they are not truthful. Essentially, if a witness makes a false affidavit and then affirms or gives an oath in relation to that affidavit, and it turns out to be nonsense, the witness can potentially face the same sort of sanctions that they might face if they were making instead of making that affidavit, if they were giving that evidence in chief. I generally say to people when they're signing an affidavit, look, when you sign this, it is exactly the same as if you were standing up in the court and reading it out to the judge. If they're not sure that everything that they've said is sufficiently truthful that they would be prepared to read it out in front of the court, you really can't have them sign it as an affidavit. The second thing is, you are there to assist the witness, but you are not there to coach them. Now, this is something that we talk about in terms of proofing a witness in evidence law, but it's way more complicated when you're doing an affidavit, because you are actually assisting the witness to put the words together. And there's a great temptation to try to steer the witness towards making an affidavit in terms that are going to be explicitly helpful to you. You need to be really, really careful about doing this. You can assist the witness, but you can't coach them. You can't tell them what you want them to give in evidence. So how do you avoid that? Well, there are three things that I think you can do. First, prepare some questions for the witness to reflect on. There's no problem with you saying, look, these are the questions that I would like your evidence to answer, and then allowing the witness to answer those in their own way. That allows you to direct the witness towards the areas that you think are important, and your questions can put some facts in play that are clearly and explicitly important to you, without actually leading them too far along the way and putting words into their mouth. Second thing I would suggest is that when you're drafting a witness, make sure that you use the witness's language and not your own language. Unless the witness is a lawyer, the likelihood is that they're not going to make their affidavit in particularly legal language. If an affidavit is made by somebody who is, let's say, a night fill operator in a supermarket, and yet it reads like something that has been written by a first-year lawyer, there's inevitably going to be questions in the mind of the court about whether or not this evidence has truly been made by the witness or whether it's been made by the lawyer and simply signed by the witness. If you're writing an affidavit, don't feel a constant need to be editing the language of the deponent. Allow the deponent to make their evidence in their own words and in their own way. The third thing you can do, however, is you can cross-examine the witness afterwards. So what you can do is say, okay, thanks for your affidavit. Now I've got a bunch of questions that I think people might want to ask you about it. And by cross-examining the witness and starting to reflect on what the witness had put in the first draft of their affidavit, it may help them to see that there are additional things that they might want to change in order to come up with a high-quality affidavit in the end. So how do we actually go about writing one? First and foremost, you need to be using the correct template. You will find that most courts nowadays will provide you with a template, and in the notes I've provided you with the links to the template for the Federal Magistrates Court and also the template which is used by the Queensland's courts. Don't try and be creative with those formats. They've been provided by the courts because they are exactly what the courts would like to see from the evidence in terms of form, and so if you stick to those, you'll be fine. The other thing is that they provide exactly the right jurat, so exactly the right words to be signed off at the end of the document to make the affidavit all nice and admissible. At the start of the affidavit, there is some usual general introductory facts that most people will put in. They identify the witness and they give some basic details about the witness. They also express in general terms how the witness came to be part of the case. After that, it's a matter of simply laying out the evidence of the witness in as logical a way as possible. And this is why for the last few years while you've been studying law, every assignment that you've ever done has required you to start laying out information in a logical way. It's in order to train you with the skills that you'll use on occasions just like this. Remember though that all you're doing is laying out facts. You're not making an argument. It's not for the witness to argue the case before the court. That's your job as the lawyer. What you're doing is providing, through the witness's statement, some basic, logically ordered building blocks, and they will become the facts that you as the lawyer will apply when you get into court. It's important to signpost each area within the affidavit. If the affidavit makes facts that relate to 5 different areas of dispute, signpost each of them separately. Assist the judge to read the affidavit. That can only help to make the affidavit more persuasive in the eyes of the court. Once you've done it, check for opinion, hearsay, and argument. Start with opinion and hearsay because they're familiar to you from evidence law. Check through each paragraph and make sure that if the deponent is providing opinion, it's just opinion that's provided in order to enable them to make sense of their observations. Check that they're not providing gratuitous lay opinion that they're not authorised to provide. Check that they're not providing hearsay evidence. If they are providing hearsay evidence, start applying all of those rules of hearsay that you learned in evidence law to make sure that they would only be applying admissible hearsay evidence. Finally, check to make sure that the witness hasn't started arguing. Affidavits are not the place for argument, and too much argument in an affidavit can actually result in it being struck out. The final thing to do after you've written the affidavit is read it as though you were on the other side. If you were arguing the case for the other side, what would you make of this affidavit? Is there anything in there that you see as weak? Is there anything in there that you see as being ambiguously expressed? What would be your points of cross-examination if you were representing the other side? Once you've thought your way through these things, you can see that you've taken a critical approach to the affidavit and assisted the witness to write an affidavit which will leave them in a strong position when it comes to the case itself. Now, you'll find that in the notes this week I have provided 2 different scenarios. One of those is the scenario that I referred to earlier about mix import rares. You'll find that within the notes there's a little cartoon animation. In that cartoon animation, you're interviewing your client, Andrew McKinlay, to prepare an affidavit which reflects the evidence which he is likely to give in relation to this dispute. Beyond that, there's a further little animation to look at where you're interviewing a witness in relation to the other dispute which I follow through in the notes, which is a copyright dispute relating to a rock song called Under a Full Moon. Have a look at both of those animations and then have a bash at writing an affidavit out for each of those witnesses. You'll find that what seems like quite an easy task may actually be more challenging than you're expecting, but by this point in the semester you're well and truly up to it. So this topic we've talked about legal correspondence and affidavits. In each case we've talked about those things that we need to consider whilst we're preparing to write legal correspondence or affidavits, and then we've talked about the actual process and the actual content for each of those types of document. I'd like you now to have a go at writing them for yourself, and I look forward to seeing what you produce on the Moodle site. Next week we'll go on and look at the final two areas of drafting for this course. First we'll look at wills, and then we'll look at contracts, and then we'll be done. Look forward to next week.